But Your Honor, but Your Honor,
it wasn't just he didn't go to community corrections. Isn't that correct?
That was, Your Honor, something may have happened prior to my appointment, but when I was appointed on the matter, he hadn't came to community correction.
Yeah, he probably came down off all those drugs. Go ahead. Any agreement or sentence evaluation or case evaluation, the court is not bound by that. You understand that?
Yes, sir.
You also understand that you could not then set aside your plea.
Okay.
You understand that, sir? All right. Is counsel aware of any other promises, threats, or inducements that have led to these pleas?
No, Your Honor.
No, Judge.
And good morning, Your Honor. Sydney Russian appearing on behalf of Mr. Jones on case ending 0697.
Oh, sir.
Morning, Your Honor. Mike Gaddy, Assistant Public Defender on behalf of Mr. Jones in case 21574.
Okay. In both cases, I have an indication or a plea agreement form that he is going to be pleading guilty to an added count 2 of use of a controlled substance in both matters, a 1-year offense upon a successful plea with those charges count 1 in each case. Yes.
That is correct, Your Honor.
That is correct, Your Honor.
All right.
I have gone over his rights with him.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Help me, God, yes.
State your name.
Quincy Jones.
All right. Sir, it is this court's understanding that you're going to be pleading to 2 counts of use of a controlled substance.
Yes.
All right. Is that correct?
Yes, Your Honor.
Those are misdemeanors, punishable by up to 1 year incarceration at $2,000 fine plus court costs. You understand that?
I understand.
You understand also in one of the cases, while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court.
Yes, Your Honor.
Understanding all of that, do you still wish to plead guilty
Yes, Your Honor.
to the charge of use of a controlled substance contained in case ending in 0697? How do you plead?
Guilty.
To that same charge contained in case ending in 0574, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, I do, Your Honor.
You signed an advice of rights form, is that correct?
Yes.
You have any question regarding any of those rights?
No, I read them thoroughly.
Pardon?
I read them thoroughly.
You understand them?
Yes, I do.
All right. So you have no questions.
No questions at all.
Is anybody, I think we look at paragraph 5, excuse me, copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that.
Yes.
You understand you're giving up your right to appeal of right, general parole?
No, I am not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
And I'm not necessarily on the record.
He's asking if anyone's made you any promises.
No.
Anybody threaten you or coerce you in any way?
No, I haven't.
You're doing this voluntarily
Yes, I am.
of your own free will,
Yes, I am.
and because you believe that you are indeed guilty of these offenses?
Yes, I am guilty of these offenses.
Okay. Starting with the case in the 14A2 jurisdiction, City of Ypsilanti, on March 14, 2025, the location of Huron Street, City of Ypsilanti, Washtenaw County, State of Michigan. Did you have cocaine in your possession?
Yes, I did.
Had you used it?
Yes, I had.
Did you know what you were using was cocaine?
Yes, I did.
And on the other matter, on the date of February 9th, 2021, at the location of 2201 Hogback Road, that being the Washtenaw County
The
Jail,
defendant
did you...
attempted to challenge the court's authority using sovereign citizen arguments, refusing to recognize the court's jurisdiction and the charges against him. Despite repeated explanations from Judge Simpson, the defendant continued to reject the legal process and interrupt proceedings.
Being the Washtenaw County Jail, did you have cocaine? Did you have fentanyl in your possession?
Yes.
Had you used it?
Yes.
Did you know what you were using was fentanyl?
Yes, I did.
All right. Sir, I need you to also understand that if I accept your plea and between this plea and the time of sentencing, if you commit misconduct as defined by the court rule, that any agreement or sentence evaluation or case evaluation the court is not bound by that. You understand that?
Yes, sir.
You also understand that you could not then set aside your plea.
Okay.
You understand that, sir? All right. Is counsel aware of any other promises, threats, or inducements that have led to these pleas?
No, Your Honor.
No, Judge.
And has the court complied with the court rule, and would it be proper to accept the defendant's plea?
Speaker was satisfied on both matters.
Yes, Your Honor.
Defense is satisfied, Judge.
Court will accept the defendant's pleas of guilty to count 2 in each of the cases. Count 1 is dismissed. In the 1482 matter, pre-sentence investigation and report is ordered at 1482 probation. Sentencing in that case will be July 9, 2025, 10 a.m. That is before Judge Barr. Bond on that matter will continue.
Your Honor, may I address Bob?
I knew it. I was trying to sneak it in before you said something, Rushing. In the other matter, let me just finish up the other matter. In the other case, defendant is count, if I didn't say so, no form. Count 1 is dismissed, except the plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1481 probation. Sentencing will be
July 30th, 2025 at 12 p.m.
no. I have a sentencing. 9th, he's in custody. That's the date we'll give. July 9th, 2025. Time?
9 a.m.
9 a.m. So you can come here and then get over to Judge Barr, and that's before me. As to bond.
Your Honor, I'm asking that Your Honor consider reducing this down to a personal bond. Bond was revoked because Mr. Jones failed to come to community corrections. I know Your Honor is very well aware of the last time. Exactly. But Your Honor, but Your Honor,
It wasn't just he didn't go to community corrections. Isn't that correct?
that was, Your Honor, something may have happened prior to my appointment, but when I was appointed on the matter, he hadn't came to community corrections.
Yeah, he probably came down off all those drugs. Go ahead.
Oh, well, Your Honor, that's new information to me. But at this time, he has accepted responsibilities in this matter. He will appear at his sentencing date. I've had a conversation with him. He understands that he does need to turn himself into community corrections and he does need to test. So I'm asking Your Honor, consider reducing this down to a personal.
With the social worker assisting him from Avalon Housing, and they are prepared to help him engage to whatever extent is necessary.
Any response from the people?
Yes, Your Honor, and happy to fill in Ms. Rushing as well. Prior to her appointment on that other matter, Mr. Jones had appeared in court extremely under the influence of multiple drugs that he admitted to. I think it was cocaine and THC at the time. Not sure what else may have been in his system. The concern of the people added to that is that prior to that, Eric's in court under the influence, Mr. Jones had actually been in treatment and been hospitalized. So I'm very concerned that he's just not able to comply with the court's orders of saying for using drugs. And it was then that his failure to report for testing after that occurred after he had still been allowed to be released on PR. I would prefer that he at least remain in custody until his sentencing on July.
Have an additional evaluation. I'm going to deny the request for any type of bond reduction. Defendant bond will continue in each poll.
Thank you. Thank you, Your Honor.
Thank you.
Happy holiday, Judge.
Yes, and to you.
Have a great day.
Prosecutors cited the defendant's history of failing to appear in court and involvement in multiple active cases, arguing that he posed both a flight risk and a danger to the community. After reviewing the circumstances, Judge Simpson increased the defendant's bond from $10,000 to $50,000 cash in each case.